Ladies and gentlemen, welcome to the Directors Hour hosted by Fluid Rock Corporate Governance and Stellenbosch Graduate Institute. We're very happy to have Pattinson with us today as a guest, talking about business rescue. It's a misunderstood tool and how to plan for the unknown unknowns and unknowable unknowns, I think, as well. And I'm very interested in this topic because I think for the average executive, it's something which comes up every once in a while. It's definitely something that we always talk about when we're looking at mergers and acquisitions, to understand what is the impact of potential business rescue. And also, I think in COVID times, it's often a thought to understand what this is about. But yeah, the information isn't always as clear and often shrouded the mystery. So very happy to do that. So Ronald, you'll lead us through this, and I'll try to ask intelligent questions as we're going along. And also, if at any given point in time you've got a question, please ask it in the meeting chat, and I'll ask it into the forum. Okay. So over to you, Ronald.
Thanks so much, Rian. Welcome, everybody. We're all now in different spots. So some people are quite cold, some people are quite wet. So we're very happy to continue our Directors Hour. We started this somewhere last year when COVID first hit, and we're going strong. We're getting quite a lot of requests for different topics. So if anyone wants us to discuss something specific, it doesn't have to be related to business rescue, please pop it in the chat. We'll make a note of it, and we will definitely deep dive into that. Like Rihanna said, I'm Ronald Klein. I'm the CEO of Fluid Rock, the governance group. We deal a lot with companies that are in distress, that are finding it difficult and challenging, and we realize that it's a very business rescue and all the other mechanisms in the Companies Act is quite a misunderstood tool. So just to have a quick overview of a director's duties. So one of the duties of a director is to ensure a company is solvent and liquid. Now, a lot of times this is treated as a tick box approach. And I'm just going to pause there for a second. If you can just go on mute, there's a little bit of feedback. And I think it will just be easier for everyone if people go on mute, and then you can ask questions in the chat as well. So if you are a director, it's actually your duty to make sure that the company is solvent and liquid, and that you do everything in your power that the company remains solvent and liquid. It's not just a checkbox. But then, of course, we're hit by a once-in-a-lifetime event, I'm hoping, that like COVID. And of course, we know that some industries and some companies have been hit incredibly hard, and we're going through unprecedented times. That is why the legislator in the Companies Act has made some provision for some relief mechanisms to help companies. Sometimes you just need some time. You just need a bit of time to restructure or change or to get back on your feet. It's a well-intended process, but of course, like everything, it is quite complex. It can get quite technical. So I don't think the idea is to get too technical today, but it's really to kind of understand what is there, what's going on, what are the topical issues, what are the things to look out for, what are the different stakeholders' duties, and that is why we have Pat here today. So Pat has a lot of experience in turnarounds. We handed out we provided his full bio. But Pat has a lot of experience in turnarounds and business rescues. He's assisted around 200 clients with informal turnarounds, and then he's done around 60 formal business rescue proceedings with an astonishing 95% success rate. When last I checked, it was more like 10%. And Pat is a senior business rescue practitioner. You do get 3 different levels. You get the junior, the mid-level, and the senior. And that depends on how big a company they can take on. Pat often advises the creditors on their rights and duties during this process, which is quite an interesting angle. We'd like to hear more about that, Pat. And then just a disclaimer, because it's such a hot topic, none of the views expressed today is any of the individual companies' responsibilities. It's all our own views, so we can be quite controversial. So Pat, if we can hand over to you, please help us understand what are the available options to companies, and then please hone in a little bit on business rescue, just to set the scene for us. Okay.
Certainly. Now, thank you very much for having me today, and thank you everybody else for wasting your valuable time and listening to me. I will try and give as brief an overview of business rescue as I can. But as Ronel said, I am a member of the TMA, the Turnaround Management Association, and a couple of other associations. So I just want to start off with that. The views given here are my own and not necessarily connected to other associations that I do belong to. Business rescue is, as you say, a very misunderstood tool. And unfortunately, I'm going to need to get just a little bit technical in order to expose and explain that to everybody. But I'll try and do that as quickly and as briefly as possible to give us ample time to actually discuss and have a conversation. So business rescue as the misunderstood tool, just confirm that you guys can see my slide, please.
We can, definitely.
Perfect. So I'm going to give you guys a bit of history very quickly. Business rescue in its current format was introduced 2007, amalgamated 2008, first business rescues implemented in 2009. However, it comes from a previous part of the Companies Act that was referred to as judicial management. Judicial management, to a great extent, failed to various reasons, which is a presentation on its own. But the biggest part of the failure was that it was a court-driven process, and the creditors and staff had very, very little input. So business rescue was then introduced into the Companies Act 2008, first one in 2009. And case law states that it must be preferred above liquidation for the simple reason it is there to save jobs as its primary function and then to assist our economy in going forward. Every business that liquidates have got a substantial snowball effect on the companies and industries around it. So it's in everybody's best interest to try and save those businesses, as Ronel said, that just needs a little bit of time, a little bit of restructuring and a bit of a break from the creditors. Unfortunately, business rescue is not available to all forms of companies. Trusts, sole proprietorships, cooperatives are some examples that are not permitted to go into business rescue. Now here comes the technical part, and I will try and scan over this very quickly, but I think you guys will get the point I'm trying to make. Section 128 states the reason for business rescue, or the purpose of it, which is to rehabilitate financially distressed companies. It further states that should the rehabilitation not be possible, that you can provide a better outcome than that of immediate and traditional liquidation. And this is an important point that we're going to discuss a little bit later, I think, in the conversation when it comes to what do we consider a successful business rescue versus a failure. Now, it's a confusing part of the legislation. For example, Section 129 says a board of a company may resolve to file for voluntary business rescue if the company is financial distress and there's a reasonable prospect of a rescue. Case law makes a reasonable prospect very, very simple, so we're not going to talk too much about that. We'll have a quick look into what it means to be financial distress. So financial distress simply says that it is reasonably unlikely for a company to pay its debts as and when it becomes due in the immediate ensuing 6 months, or it is likely to become insolvent within the immediate ensuing 6 months. So it doesn't have to be both. It is one of the two. Now, being financial distress, can't pay your debts, means if you are aware that a debtor is not going to pay you, you know that you're not going to be able to settle certain debts, be it salary, SARS, rent, a supplier. If you have the need to go into a payment arrangement, any of those things means that you are financially distressed. It does not mean I can't pay my debts now, but should I be paid by a debtor later, I will be in a position to. Or if I increase my overdraft, I will be in a position to. At that point in time, you are financially distressed. The same exercise is for becoming insolvent. It is not right now, it's how you see yourself in the next 6 months. And then as the Companies Act says, you may file for business rescue, or you can opt for insolvency in terms of a liquidation, or you can go for a Section 155 turnaround. So once we go past the may, because that creates the illusion that the company and its directors may decide to go on a different avenue. However, if you read a little bit further, you go to Section 129.7. It gives you the fact that if you've decided not to file for business rescue, and you know you're in financial distress, you have to file a written notice to each and every affected person confirming our business is in financial distress, but we have decided not to go for business rescue, not to opt for liquidation because of XYZ reasons. It sounds like a very simple alternative, but we then go to Section 8G of the Insolvency Act. And that clearly states that given such a written notice is an act of insolvency. And then we can go further into the various forms of the Act, Section 22, Section 214, where it's quite clear that should the directors of a business trade in any circumstances that is reckless, negligent, they could be held personally liable. When we look at the test, that's both a subjective and an objective test. So not just what the directors know, but also what they should know. At the same time, any professional accountant, whether you are employed by the business or provide external services, or even if you're having a chat around a bribe, becomes aware of this. They have got certain obligations in terms of Section 225 and 360 of the Urban Code of Conduct. So business rescue, there is always the carrot and the stick. The stick to it is the responsibility of the directors. Section 214 states, if you knowingly provide false or misleading information, it sounds like a very harsh punishment and far-fetched, but if you are in financial distress, you know you're in financial distress and there's been a single invoice that you could not pay. The moment you place an order with a supplier, you are placing that order knowing that you cannot settle all of your debts. And you are therefore providing misleading information, because when you place that order, you provide the impression that you can settle that debt, but you know that you can. There are also criminal liabilities, which is a lot more difficult to prove, but the potential is there. We've also got the stick of 2182, where any person who contravenes any act is personally liable to any other person that has suffered a loss. So these are the technical points. We go back to Section 22 of the Companies Act, reckless gross negligence, whether it is your intention to defraud or fraudulent purposes or not, 2182 will apply. So the process of business rescue is very simple. We're going to talk about the voluntary process for today and not the court one. There are two ways to enter into business rescue, either by resolution from the board, or any affected person can approach the court and force the company to go in. The board files a resolution, they appoint a business rescue practitioner, they notify the creditors, the practitioner have got a certain amount of time to publish a business rescue plan, and the creditors vote on that plan. And this is where I'd like to take a pause, and I think it's important for our discussion today. Business rescue is a creditors-driven process. Throughout the process, the creditors are allowed to take part of it. They're permitted to form committees. They're permitted to communicate to the practitioner. They will vote on whether extensions are allowed. They vote on a practitioner's remuneration if it falls outside of Regulation 128. And ultimately, the creditors vote in favor or against the adoption of a proposed business rescue plan. So the power ultimately lies with the creditors. And this is where I often assist the creditors to make sure that the process is followed and that they understand their rights during the process of business rescue. The benefit of business rescue, very simply said, prevents liquidation, saves jobs, and that's the main thing as far as I'm concerned. There's no legal action that can be taken against the business during business rescue. In terms of Section 133, there's a complete moratorium on any legal action taken against the business. That obviously does not include criminal actions or actions against the directors or shareholders or any party that has signed surety. It provides for the restructure, and the restructuring is not just as far as the operations of the business is concerned. It's also the restructuring of the debt. It could allow for a payment plan where the company is allowed to pay off the debt over a period, 12 months, 24, 36. I've seen plans with substantial amounts going up to 7 years. There can also be a compromise with creditors where they state, we will pay 50 cents in the rand in the next 7 days or 7 days after the adoption of the plan. However, the most popular business rescue plan is where there's a combination of the two, where the company commits through the business rescue plan to pay 70 cents of the debt over a 12 or 24 month period. Then there's also the tacit threat, almost blackmail from a lot of practitioners, where they compare the outcome of the business rescue to that of immediate and traditional liquidation. Now, without being too technical on this point, the Companies Act says that the purpose of business rescue is to rehabilitate a business in order for it to continue on a solvent basis. Failing this, and that's important, failing that, the company may ask the business rescue practitioner to prepare a business rescue plan that provides a better outcome than that of immediate and traditional liquidation. That's then also further confirmed in a Carroll versus Carroll matter, where the business rescue plan was implemented. The end result of that business rescue plan is exactly the same as a liquidation, except the time periods were so much shorter, and ultimately the creditors and staff received substantially more than what they would have received in an immediate and traditional liquidation, because the fees and cost that is normally contained in Section 89 of the Insolvency Act is quite substantial against the fees that practitioner should and can charge. And don't stare blindly against Regulation 128. That's the maximum a practitioner can charge, not necessarily what he should charge. In some of my smaller business rescues, I charge a fraction of that fee. And if it is a fair enough business, I sometimes even swap my fees for some equity in the business, and then they pay me off at a later stage. That's to assist the business by paying the creditors first and then looking after me at a later stage. So that's the presentation I've prepared. I've been asked to keep it brief and to leave a lot of time for questions, as I'm sure you will have. So yeah, back to you, Renal.
Thanks so much, Pat. One of the main criticisms against business rescue is that it's also an expensive process, and we have to pay the business rescue practitioner's fees first. Not everybody like you are prepared to wait or take equity in the business. So what are your views about that?
Look, I do understand, and I think it's a very unfair process, the fees that some practitioners do charge. However, it's a very specialized field, and the practitioners do have a lot of liabilities. But again, Regulation 128 is the maximum that can be charged. 134 then gives an opportunity for the practitioner to ask for contingencies. But I believe if you have a decent practitioner for a fair business, they would be prepared to negotiate on that pricing. They themselves can enter into payment arrangement. And ultimately, before a board of directors passes a resolution, they must consider that cost. And they must consider the practitioner. Are you going to get one that's going to insist on charging the full price? Or are you going to look at someone who's prepared to go into a contingency where it says my fees should be R2,500 per hour? I'm prepared to make 50% of that part of the contingency. However, at the adoption of the business rescue plan, I would like X contingency, substantial implementation, I want X. You know, it can go as far down that if any of the assets are sold, that the practitioner shares in a certain portion of that. And if we compare that to liquidation, Section 89, there are certain governed percentages a liquidator can charge. My rule of thumb is that I normally, as a contingency, ask for 50% of that on condition that the creditors receive a minimum of X percentage in the rand. And remember, the practitioner can only present it to the creditors. If he goes for any form of contingency, the creditors must vote on the approval of that contingency before he's allowed to start receiving it.
Okay.
But yes, it can be an expensive exercise.
Yeah, there's some questions just from the chat, and I think one of this is, can fees be done on a success rate?
Yes, the Companies Act, and again, not to be too technical, Regulation 26 lets you know the size of a company, 126 practitioner, 127 who may work where, and then 128 gives the fees. Now, again, the fees are the maximum that a practitioner is allowed to charge. But yes, he can say 50% of my fees I will charge now, the rest as a contingency. And another thing that I've got a personal bit of a problem with, if you look at a small business, a junior practitioner may take on a small business, and a junior practitioner's fees are, for instance, 1,200 Rand an hour. Now, the company battles to find a practitioner, or they decide to employ a senior practitioner such as myself. I do not think it's then fair for that senior practitioner to charge senior rates for a small business. And that is where the creditors and the company must negotiate the fees before they employ the services of a particular practitioner. But yes, anything is possible. The Companies Act only stipulates the maximum fees.
Cool. Can a creditor place a state-owned entity under business rescue?
If they are exceptionally brave and they have a lot of money, there's nothing that prevents them from trying. I would not do it though.
Okay. In a case where workers are owed a lot of money, can this be turned into worker equity? And if so, has it been tried before and what were the results?
It has been tried. The results was very, very disappointing. For many reasons. It's not necessarily a failure of the business rescue process itself. The particular matter that I'm aware of, that I won't give details of, once a trust was formed for the staff, and that trust became the equity partner in the business, the members of that trust, or the beneficiaries of that trust, who were the staff, unfortunately became of the opinion that we are now shareholders and we can dictate and we are entitled to salaries, which caused conflict, and the whole thing actually fell apart because of that. In my mind, I think if there was a little bit of education for the staff, it would have been a completely different thing. On the point of staff, staff are considered into two sections in business rescue. The debt prior to the filing becomes concurrent debt like any other concurrent creditor. However, the debt after the filing of business rescue, all of those salaries become automatic post-commencement finance.
Okay. That's so interesting.
And before we go on, do you mind if we go back to Louis' question about can a creditor place a state-owned entity under business rescue? The reality is a lot of smaller businesses are owed a lot of money by state-owned entities. And if they could just pay, these smaller businesses wouldn't be financially distressed and they would be in a better position. So if we can just hover on that a little bit. Now, we can't go through this webinar today without mentioning SAA, right? So, I mean, what happens is, and if we can answer Louise, that anybody can actually, any affected party, right, can take, can apply to the High Court to put a company in business rescue. So should you have the funds, you would have that. The problem is I think, and you can give me your opinion, is that most likely you'll get an opposition to this application to court. Is that right?
It is true that any affected party can place any other party into business rescue by application to court. The difficulty comes in when that application to court needs to be motivated in respect of proving that the company is financially distressed. Now, government entities have got government money and they can simply say, we're not financially distressed, we've got the backing of XYZ partners. That's the one point of it. In addition to that, in your application, you must stipulate why you believe that the company is financial distress and not just paying you. And you need to have access to the financials and all sorts of things. So although in theory it can be done, it is not that easy. But in short, yes, it can be done.
And just a thought that comes to mind, is there an opportunity for class action in that, in the sense that if there's a group of people that need to bandy together, would that be a natural opportunity, maybe Ronel?
Yes, it has been done in the past where groups of creditors have submitted an application to court. However, the court still says you have to prove financial distress and then you have to prove a reasonable prospect of a rescue. Now, unless you are really involved with that business, proving those 2 points, whether you're a group, a collective, or one entity, is where the difficulty comes in.
Very interesting.
Thanks.
Okay.
Then continue with the question from the chat.
So there is a question around why are financial institutions reluctant to grant post-commencement finance for companies under business rescue, and why in most instances such financial institutions elect to suspend its facilities with the company pending a renewal application by the business rescue practitioner appointed?
Okay, so when we talk about financial institutions, we're talking about the banks and other private funders. The one thing that we must keep in mind when we talk about post-commencement finance is that any person that wants to provide such capital, unless it's connected, needs to be registered with the national credit regulator. So that put a bit of a pause in front of any individual or other company that might want to provide finance as far as their ability to charge interest goes. Then if we look at the banks and other funding institutions, we must remember that all businesses, including banks, are there to generate an income and a profit for its shareholders. And for a business to provide finance or assets or credit to a financially distressed business, in any other format would be considered reckless. If you were to provide assets to a company that you know can't pay its debt, in most instances, that would be considered reckless credit or reckless trading by the directors. Now, banks are no different. They need to make sure that their debt, that their exposure is covered in some form or another. And that is what makes it difficult. Yes, there are certain preferences and certain conditions that post-commencement finance provides, but ultimately, those conditions only kick in when the company is being liquidated. And then those post-commencement financiers still have to go and stand in line behind court fees, liquidators' fees, auctioneers' fees, behind the staff, behind SARS, and behind any other creditor who has provided any other form of or who was provided any other form of security prior to them. So it's not a quick 30-second answer, but I do understand the reluctance of the finance providers. If I wouldn't provide capital, why should they? And that's the question creditors must ask. If they expect the bank to provide PCF to a client of theirs, are they prepared to do the same?
And just a practical question, maybe from my side, just as a follow-up to that. So,
okay, so now I'm in a situation where I don't really have the cash. The banks won't give me the money. Staff can't really sue me. But I also can't pay them. Is that the correct way to think about this?
Yes, so the availability of post-commencement finance, so cash injection into the business after you go into business rescue, is absolutely key to the success of that business rescue. If you can't get post-commencement finance, you probably won't be successful in business rescue. It also depends on the kind of business rescue. We had a business rescue with a client who just were waiting for some of their supplies to arrive by ship at the port so that they could then deliver it so that they can get cash. So in that case, it wasn't really necessary to get post-commencement finance, which Pat calls PCF. But that's exactly the problem, is that if your PCF is not secured, you're probably not going to survive. So one of the first things business rescue practitioners normally do is they do look for providers to say, what is the likelihood? And some of the business rescue practitioners, before they even take it, they look at the chances of you getting post-commencement finance. Otherwise, the success rate might drop. I don't know if that's what Pat does, but that is a key question. It seems we've got connectivity problems with Pat. So until he comes online, we can continue. There are some other questions as well. If we can say...
There's a question. There has been cases in the past where the business rescue project has been driven towards liquidation and process just to access the assets. What's your opinion on this?
I've definitely seen that as well. And that's why the appointment of the right business rescue practitioner who's got good credentials in the market is so important. I've seen it also where because how it works is that if you're in business rescue and then go into liquidation, that it can't be the same people, so you can't benefit from it. But what happens, it's people who know each other and there's relationships between them. So that's definitely there. I've seen that as well. And it's my opinion on that is that it is absolutely unethical, but it has happened.
Hi. Okay, good. Nala's just been telling us about how some of the business rescue proceedings have worked, and we talked a little bit about the criticality of post-commencement finance, even before you go into the business rescue process, that you understand that there's a reasonable process ability that you will be funded. Otherwise, I guess that liquidation becomes the best option.
Yeah, just on the point of post-commencement finance, if we consider that a company is supposed to file for business rescue 6 months before they become financially distressed, obviously at that point in time, they should have a little bit of money left. And if they act early enough, the banks and lending institutions will be much more willing to provide capital. But a lot of companies wait until they're really in a position where they've already exhausted everything. They don't have money for salaries. They must pay salaries on the 25th, 24th, they file for business rescue, and they expect everybody to help. That's unfair from everybody. You need to file for business rescue, if it is necessary, as early as possible.
Excellent. And on that, we've had a scenario before where we were looking at an acquisition from an M&A perspective, and one of the strategies was that we realized that this company would be in distress, and to then file for business rescue until we could rehabilitate the company. Is that a valid way to think about it?
It is a valid way to think about it, yes. In practice, a lot of businesses that go into financial distress, one of the few outcomes available to them is to actually sell off the entity. But it also quite often happens that a business places itself into the market, and then through the due diligence, they realize that we will not be able to continue trading until the transaction is done. The entity is put into business rescue, and then it is sold as part of the proposed business rescue plan. So yes, it's a definite way to do it. It's a very clean way to do it, because on the other side of business rescue, once a plan is adopted, that business rescue plan is binding on all affected parties, whether you knew about the process, whether you voted for it or not. So the new owners know that they get a business where the likelihood of a skeleton falling out of the closet doing any damage is minuscule.
So interesting. Definitely useful guidance. Renal?
Right. Pat, can you maybe share with us, just on a little bit of a positive note, can you share with us one of the business rescues you've done that has been successful, and what has been some of the key elements that were present in this successful turnaround?
Well, the majority of my rescues are successful. Some has been better accepted than others. Some rescues we unfortunately have to sell the entity away from the current shareholders and directors. They were not necessarily too happy with that. We've had fun and games where I have actually dismissed certain shareholders and directors of a business. Those are obviously on the onset not a good story, but if you look at the outcome and you look at the reasons why these entities went into business rescue, the problem was those at the top. And the unfortunate reality is whenever a business becomes distressed, the first thing that people want to do is start looking at retrenchments. But more often than not, those that are the victims of retrenchment are not the ones that were part of the cause of the problem in the first place. We've had a rescue where the two owners, a very recent one, where two owners of a business passed away very, very shortly from each other. In a space of 30 days, both owners passed away, and there was a business that was left completely rudderless. No one could get access to the financing into the bank. The executive of the estate then appointed myself as a practitioner. We looked into the business, and although we were not able to settle all of the creditors 100 cents to the rand, we were able to sell off certain entities, certain sections of that particular business, ensuring 100% of the staff retained their jobs. And that was 74 staff members who in other circumstances would have lost their jobs in November, very close to the December holiday. So to me, that is the ultimate success rate, where you've saved those many jobs, where outside of business rescue, there simply would not have been a way to avoid liquidation.
And just an interesting kind of follow-up question to that. You say that you dismissed those directors. To what extent do they remain liable relative to, obviously they got the business into this position, and I know that would be on a case-by-case basis, but just as a general principle.
All right, so the reasons that I have suspended and even dismissed certain directors in the past was for a complete lack of fiduciary duties, disrespect to the process, that type of thing. But putting that aside, in general, if you look at the powers of a practitioner, in terms of section 140, 141, he has to investigate the affairs of the business immediately before the filing of business rescue to determine what the reasons for the distress and everything else was. Unlike a liquidator, a practitioner is not provided with any investigative powers. He cannot investigate, force people to take part in certain investigative sessions or interrogations, similar to what a liquidator would have been allowed to. A practitioner's obligation and rights stops by him having to report those omissions or commissions of certain acts that is not proper to the correct authorities, and those authorities would then ultimately decide whether they want to pursue the matters or not. It would unfortunately have to come from the creditors on whether they want to take those directors on in their personal capacities for the losses that they have suffered. Practitioner unfortunately does not have those powers as much as he might have wanted to use them.
Okay. Excellent. So then I guess that the company could post the proceedings, still pursue action with that director?
Yes, even in a business rescue situation where the business rescue plan is adopted, creditors has accepted a certain compromise. If the creditors believe that the directors of the company acted maliciously or in contravention with any act, they are still permitted to go after those directors for the losses that they have suffered. Even personal surety, a traditional and standard business rescue plan does not waive the sureties that any director or other party have signed. There's certain case law on it that if the practitioner makes specific mention of it in the rescue plan, then those sureties are waived, but the creditors vote for or against that. And they do not have to reject the plan in totality if they're not happy with a certain section. Section 153 of the Companies allows any creditor during the meeting to vote to ask the practitioner to either make certain amendments in the plan or to even adjourn the meeting, ask the practitioner to provide a completely new plan and repeat the process. But ultimately, any creditor, if they've suffered a loss, can go after any other person that have caused that loss after or during the business rescue process.
Excellent. We have a question on business rescue versus judiciary management. Which one is a better devil and why?
Well, judicial management, from what I understand, and that's a little bit before my time, admittedly, every single decision that the judicial manager wanted to do, sell certain assets, retrench certain staff, pay a creditor, employ a staff member, would have to be approved by the court. The smaller decisions could possibly be done in chambers, but the rest of the time there had to be a court proceeding, which delayed the process substantially. The court would also normally appoint someone who would try and run the business remotely. Creditors had zero say in it, and I think that's the important thing. Creditors must understand their rights, what their votes are, what their inputs are during business rescue. And for that point alone, the input from creditors, I believe the business rescue is by far the better option and the better devil than when you compare it to judicial management.
Awesome. That's definitely a valuable perspective.
And then let's not forget that judicial management is no longer available.
Yeah. You mentioned that the court could instruct or initiate this process, and I was also thinking from that perspective, what's the process there? Is it different?
Yes, it's very different. The court cannot do it out of their own. Our courts are not investigative courts. It is approval or rejection of applications. So a creditor or an affected person would actually have to apply to court in order to have another business put into business rescue. So yeah, it's not the court on themselves, it is still done by application.
And then I guess then the board doesn't get to vote on the proceedings from there.
No one gets to vote if the court is the only person who would make that decision. Votes taken during a business rescue proceedings, any vote other than contemplated in 151, which is the vote on a proposed plan, is by a simple majority, one hand per creditor. And then during the meeting to vote on a proposed business rescue plan, the vote is done directly proportional to the debt owed by the business to the creditors present at the meeting who exercised their votes. So there your vote is in proportion to your debt, and only then.
Cool. Sure. Okay. I'm learning such a lot here. It definitely is interesting. I think we've got all of
unfortunately, business rescue is very technical, so I can't give non-technical answers.
No, that's the, and I must commend you. Your knowledge of it is really deep, and it gives us a great sense of what's actually involved. Great.
Rian, I just want to check that we've answered Jonita's question. She's asking, in terms of a company's size, annual turnover, at what point is it worth going the insolvency route rather than the rescue turnaround route?
Sorry, I missed that one. Thanks.
Okay, so that's also a very, very technical question, and the answer is never. The only time you would consider liquidation above business rescue is when the outcome of a liquidation is better for the greater body of creditors. And the only instance that I would say that is a better option is when there has been such malfeasance or reckless trading from the directors that a investigation or interrogation in terms of section, I think it's 143 or 113, is necessary, where you need to actually interrogate those directors and shareholders in relation to the actions that they've taken during the business that led to the distress situation. I think business rescue is always a better option. There's case law that makes it clear it must be preferred above liquidation. And believe it or not, in most instances, it's a more economical and much, much faster process.
I guess that would be a technical scenario under which the assets are worth more than the business continuing.
That's not the measurement. Remember, I said if the company can be rehabilitated, it must be rehabilitated. If it cannot be rehabilitated, it must be wound down. And then your assets will be valued the same whether it's in liquidation or in business rescue. The difference comes in as to how you pay your liquidator, your auctioneer versus the business rescue practitioner, and your additional Section 89 cost of the Insolvency Act. That simply comes down to cost. And then also, liquidation can take, at best, 430 days if you follow the court-appointed days, where business rescue, cradle to the grave, I've done in less than 96 days.
Sure. Sounds like you have some superpowers.
No, not at all, just experience. And good people that I work with.
Excellent.
So Rian, if I may, I mean, when I'm listening to Pat, and we know this from the Companies Act, this becomes a creditor-driven process. So, I mean, you have your 6 capitals, which is according to the integrated reporting framework, which is your financial capital, your human resources capital, social, natural, manufacturing, So you've got your 6 capitals, but it seems like only one capital, which is the people who hold the financial capital, has a say. So yes, fair enough, if your employees haven't been paid, they become creditors. But normally, the banks and whoever, the financial institutions, they hold the power in this process, which it seems a little bit, yes, they're financial capital providers, but don't you think that in following a Companies Act amendment bills, there should be more rights given to the holders of the other capital as well?
A very difficult question to answer, and I think that's going to largely depend on the matter at hand. Remember, if we look at the securities held by these institutions, if you have a special notarial bond, your securities are then limited to the capital that could be raised against those assets if sold on auction. Everything else go to the concurrent power. If we then look at your special notarial bonds, we look at Section 102 of the Insolvency Act, which says that staff then becomes preferent before the payment to those securities. So I do agree with you that in certain instances, those capital becomes vital, but ultimately, none of those capitals, and I mean no disrespect, means anything unless the business have got the financial capital to continue trading. You cannot do anything as much as you want to unless you have the funds available to do it.
What advice would you give to anybody on the line who is in charge of this kind of company? So what are the red flags? When should one start thinking about business risk?
The first time you cannot pay a single bill. The first time you have to make a decision, am I going to pay creditor A versus creditor B? The first time you consider that I have to go to the bank to increase my overdraft. The first time you use your personal money to put into a business. That is already too late. You must do it as soon as you see a certain decline in your business. And if you then communicate with the right turnaround practitioner, and I say turnaround practitioner, not rescue practitioner, there are options available to prevent you from going into business rescue. So speak to the right people early enough and try and avoid business rescue. As silly as this may sound, I'm not a fan of business rescue. I prefer doing the turnarounds outside of business rescue, but that is only possible as long as you do not contravene Section 129 of the Companies Act and trade in financial distress circumstances.
So, Pat, where do we find the right people?
Well, this is where I'm going to do a bit of marketing for the Turnaround Management Association. It's one of the governing bodies of business rescue practitioners. As far as I know, it's the only governing body that specializes in turnaround practitioners and that is not associated with accountants, auditors, or liquidators. I would personally go to the TMA and say, listen, this is the kind of business I have. This is the area I am in. Do you have a practitioner that we could potentially use here? Now, keep in mind, the TMA does have auditors, it does have liquidators, it does have legal people that belong to those other institutions as well. But the Turnaround Management Association specializes in turnaround. And I personally think that's the first place after you phone me that you can contact to see if they will assist you.
So maybe you can just pop their contact details in the chat.
Also, and maybe just a follow-up question on that. What kind of criteria would you propose people think about when they appoint somebody like that?
The criteria before they appoint a practitioner?
Yeah.
You are only as good as your last 3 business rescues. So you need to ask the practitioner to give you 2 references. You then completely ignore those 2 references and ask them for 2 more because the first ones he'll give you are the nice ones. Find out what else he's done, how many rescues has he done, and speak to those people and find out how the business rescue process was done. Speak to the owners, speak to the creditors, and if a practitioner is not prepared to share that information with you, maybe he's not the right person for your business. Once you've decided that he is a ethical and a practical practitioner, then go and look at his industry experience. Has he helped businesses in your industry? I know businesses are similar, and the simple rule of business is you need to make more money than you spend. But sometimes it's important for a practitioner to have actual experience in your industry. So references and experience, that's what you need to go to, and then bully him on his pricing.
Good advice. Excellent. And then Ronel as well, from a Fluid Rock perspective, what do you guys do in this world?
Well, we're the company's secretary for clients, or we sometimes help with corporate governance advice, guidance. A lot of times we're called in when we need to now draft an AG notice for smaller entities who hasn't done this before. And I personally, before we started Fluid Rock, I was the company secretary of a with RBI Holdings that went into business rescue. Now, this whole it's extremely emotional. It's very, very scarring in certain instances, and you know, it can be quite destructive. Similarly, it can be a very, very powerful tool for you to stay creditors for a little bit of time so that you get through it. But one of the things we have seen that is very important is you must understand you cannot just leave everything to the business rescue practitioner if you bring him in, because, for example, one of an important thing to do when you are thinking to go into this process or going through this process is your PR. So how do you communicate with your stakeholders? That's why it's so important to have a stakeholder framework, to know who your stakeholders are, how you communicate with them, because you don't want this to tarnish your reputation. For example, I don't know if you remember a long time ago, there was a company called Top TV who was going to be a streaming company, and they went into liquidation or business rescue, and they know more. So they really harmed that industry. And that PR is so important. It's about how do you manage all the communication, because a lot of times the business rescue practitioner is very much at a high level. They come in, they look at a strategic turnaround, you know, it's not detailed. So that is quite important things. And one of the tips or advice I can give anybody on the call is it's very important for you to continually watch your your solvency and liquidity. So how do you do that practically? So it's almost to have a cash flow, a 12-month rolling forecast, cash flow rolling forecast, to know exactly where you are now and what do you anticipate to come in on a reasonability basis. You can even do a sensitivity analysis on each line item that comes in and what goes out. And because it's only two ways to make money, right? It's increase revenue and decrease cost. And then it's as an executive, it can become very difficult to know what do you report to the board and what don't you report to the board. And if I can give any executives advice, it's about when there's doubt, there's no doubt. You report everything to the board, even if it becomes very operational when you're in distress, so that you can use your board like a brain's trust. So you can get their input, get their support, get advice, guidance, so that when you do go to shareholders for a capital injection, it's not when you're financially distressed, it's before that. But it can become very, very tricky. Thanks, Rian.
It is. And yeah, I've been involved in startups and running companies for many years, and having this information is very useful because it does give you that sense. Okay, if I can see, well, in a startup situation, if you can see 3 days ahead, it's usually a good thing. But if I can at least get a view on the future, I may be able to utilize this as a tool. In that, I think it's very relevant from mergers, acquisitions perspective, and I must thank Pat for really giving us a rundown of how this is playing out, because I think a lot of misinformation or misperception is out there in terms of just invoking this mechanism and not really understanding it. And I think you've really given us the kind of the lowdown. Really understand that it's something that you should be doing earlier rather than later. It's something that you're not doing as a last resort. That, you know, as a director, we need to take our responsibility to not trade recklessly very seriously, because if we don't, then these mechanisms as well could actually expose us, and that doesn't absolve us from a liability. I do see somebody has asked a final question. What is the company has a contingent liability which does come to fruition and may very well put a company into a very difficult financial position? What would your professional advice be to a board in these circumstances? So that's a very helpful question.
Well, the rule is simple. Will the company be financially distressed when this eventuality happens? If so, your options are there in section 129. However, if you can approach someone early enough, you could prevent possible business rescue. Let's not forget your section 155 workouts, which is part of chapter 6, but is not business rescue. The big differences with the 155 turnaround is, although a business rescue plan would still be binding on all of the creditors once adopted, it does not have to be done by a company that's in financial distress. The board of directors can go for a Section 155 turnaround plan, including a compromise or payment plans, even if the company is not in financial distress. So I think that company would be heading towards financial distress, but a Section 155 workout might be preferred as a precursor to business rescue or ultimate liquidation.
Absolutely. And that's something that, Ronald, you guys can advise on?
Yes, it is one of the bullets in the gun of the board that's available. So it's very important to understand all the mechanisms available to a board. I mean, the main option is to make money, right? To make enough revenue, to have planning in place, and to have enough retained income that's stashed, 3 to 6 months. I mean, that's the ideal. The fact is, very few companies at the moment are in that positive situation. So I think it is about watching. It's about financial controls, really watching the cash, really checking the cost line, seeing what's and that's the duty of executive board to make sure that all of that's in place.
Awesome. Okay, so we have 1 minute left. So I think the person meeting to ask when does the board pull the trigger. I think we really did get the answer. It's as soon as we cannot pay a single bill, that's already too late. Okay, so we need to look at our prospects for the next 6 months. If we have a view, that's when we pull the trigger. I think we've gotten some really solid advice here, a really nice addition to this director's hour, and I think we're all going to benefit from a better understanding of that. And if you're looking for practitioners, look for people with experience, look at their references. Remember, we need to look at our business 6 months in advance and make these calls, because otherwise it becomes a little bit harder. And really, there's a whole range of different things that we can then pull on. And to liquidate isn't the only option. And as well, I think the board has a couple of different guns that they can play. So those are the things that I'm taking out of this, and I hope that we've all. Thank you so much, Pat. Thank you, Ronald, for putting this together. And as always, we continue our collaboration. And we've got a very good program on effective directorships. And this is then a component that we cover in that as well. Thank you so much, everybody, and thanks for joining us today. Yeah. Okay.
Thanks, Rian. Thank you, Pat.
Okay.
Thanks, Rian. Thanks, Sean, and thanks for everybody. Appreciate it.
Cool. That was great. Thank you so much.